Jesse Ziegler with Bassberry and Sims in the Nashville office, and it is my pleasure to introduce trial lawyer Rick Barnes with Goodell DeVries in Baltimore. Rick is going to discuss how federal regulations may bar state actions even without express preemption. This is because courts have become more receptive to implied preemption defenses, especially where compliance with a state law would require federal government permission. Rick is going to keep us informed about how courts have an increased willingness to recognize the impossibility preemption as a complete bar to state law claims. Please welcome Rick Barnes.
Good morning, everyone, and I hope you enjoyed your break. It's 2016, and we're in a political season, and one thing we hear constantly is that the scope and burdensomeness of federal regulation needs to be addressed. And that may or may not be the case depending upon the regulation and what's going on. However, the scope and the pervasiveness of federal regulation may provide us with an opportunity for a complete defense. And this doctrine is called preemption, and it is an opportunity, and it might impact your business if you're heavily regulated by federal law. So this is a constitutional law question. It invokes the supremacy clause. So what is federal preemption? Federal preemption occurs when a federal law supersedes or supplants state law or state law regulation. And this is a very basic definition, but in practice, the preemption defense is very complicated and requires, in some instances, years of planning to create the necessary factual record to compel a court to look at the situation of the defendant and say it's a matter of law that Congress intended to preempt state action and give the federal law preemptive effect. So what are our jobs as lawyers and litigators? Our job is to do two things really, and really address two challenges. One is that regulatory practice goes much faster than the law, which is incremental in the way judges view things. So the practical realities that your business might face would raise a conflict perhaps between state and federal law. Well, the law is many years behind that, and our job as a litigator is to basically convince the court that the practicalities of your business, that you cannot comply both with state and federal law. We had an earlier speaker named Joshua invoke Moses. Well, I'll invoke the Bible too, and that a servant cannot serve two masters, right? So that's really the goal, is to convince the federal judge that you, the defendant or the corporation or whoever's being regulated by federal law, cannot serve both a state law and a federal law. So let's proceed and just go through some of the basics. All I want to do today, this is a very dense area of federal law and sometimes state law. So I want to just paint a framework for you in how to look at these questions, especially when you spend a lot of your time trying to comply with a myriad of different laws. So the first slide really is federal preemption. This is maybe what we call the taxonomy of federal preemption. And so what you see is there are two types of federal preemption: express, where Congress expressly preempts federal law, then implied preemption. And then you can break down implied preemption into two different species of preemption, so to speak: field and conflict preemption. Then there are conflict preemption. There are two types of preemption. That's impossibility preemption and obstacle preemption. And each one of these areas of preemption involves a lot of different principles. So we'll try to simplify them for you this morning. Express preemption. Well, the case that, a very good case to read if you wanted to learn about this is Regal versus Medtronic. In that case, the court found express preemption of claims seeking to impose different or additional safety requirements on medical devices where it received a special kind of approval from the Food and Drug Administration under the pre-market approval process. So what is the question that you need to address in any case where the Congress has explicitly given federal law preemptive effect. And that question is, does the state law question, does it fall squarely within the scope of the preemption clause in the federal statute? And so what you need to do is convince the federal judge that what the state law requires you to do falls within the purview of the federal preemption clause that's embedded in the statute. This is the dream scenario. It's the easiest to litigate. It's not simple, but when you see an express preemption clause, your job as in-house counsel or as a litigator is to convince a court that the preemptive scope of the federal law covers the state law. And that is a fairly clean argument, and probably when you get this, you can basically go pretty hard and get the relief you seek if you convince the judge that the scope covers the state law. But I'm going to spend most of my time on a more difficult and interesting area, and that's implied preemption. And implied preemption, it's broken down into a couple areas, and one is the field preemption. And field preemption reflects the congressional decision to foreclose any state regulation in the area, even if it is parallel to federal standards. So a court must be convinced that there's absolutely no room for state action where the federal laws has covered it. So you raise the inference of exclusivity is what the cases talk about, and it's based upon the predominant and pervasive nature of federal law and regulation in this field. So what is the classical area where field preemption applies? Federal immigration policy, for example, might be the best example. That may not apply to a business, but it's you really start with the line of cases, and then you can go into your area and see if the federal regulation on this subject is so pervasive that you might be able to raise the implication of a congressional intent to preempt. The next area of conflict preemption is impossibility preemption. And I've done a lot of impossibility preemption work, and you really become a constitutional lawyer, and that's kind of something that we don't really deal with very often. But when you get into the area of preemption, you're really dealing with the supremacy clause. And so there are a lot of constitutional law principles, and it's really a very interesting part of the law. So the question you need to answer for impossibility preemption is this: can the party do independently under federal law what the state law requires of it? And so that's really the dilemma you're in under impossibility preemption. So the best case that I refer to learn about impossibility preemption is this Pleva versus Mensing, which I'll address in a minute. But it found impossibility preemption where it was not lawful under federal law for the manufacturer to do what a state court plaintiff's lawyer was suggesting in his or her complaint. Conflict preemption. There's also impossibility preemption. Obstacle preemption. And the best example of obstacle preemption is a case called Geyer versus American Honda. In that case, there was a really bad motor vehicle accident, and the American Honda vehicle did not have a driver's side airbag. And the plaintiff contended that was mandatory and should have been included in the design of the product. Well, federal law said something very different. They actually had considered making driver's side airbags at this time mandatory for all vehicles in the United States, and it was rejected. And the federal policy went into great detail as to the need to have alternative methods of passive restraint systems. And so in that case, even though there was a really compelling injury, and in fact the vehicle didn't have a driver's side airbag, the court held that going forward with the plaintiff's theory in this case would be an obstacle to important federal policies, and American Honda was given a summary judgment. So if you're in an area where you think there's an obstacle preemption, you would start with American Honda, Geyer versus American Honda, as probably the best explanation of this principle. Let's go back to impossibility preemption. You have 3 cases where it really speaks to how you have to be persistent and not be discouraged and keep pushing this preemption principle. And this is in the pharmaceutical area where I do a lot of my practicing. So it really starts in 2007 with the case of Wyeth versus Levine, which was out of New Hampshire. And this was following some of the case law in the medical device field where we were trying to get a similar extension of preemption into the pharmaceutical world. And in that case, Wyeth had an old drug and it had an FDA-approved warning, and the label talked about how the drug was to be administered. Well, there was one aspect of how you administer this drug through intravenously that might result in a pretty adverse outcome, and that really wasn't in the label. It was a very, very rare event. Wyeth moved for preemption, and I'm summarizing a pretty dense factual history, but they said that it was preempted because FDA approved it. The basic tenet of that case was no, just because FDA approves it doesn't mean that you could not effectuate the change. In fact, there's a regulation which allows the change being effected in advance of FDA approval. And so at that point, the FDA said, the court said that it was not impossible for Wyeth to have obtained a new label and have warned of this risk. So at the end of the day, the pharmaceutical bar was a little bit, alarmed that, gee, we were not going to get federal preemption, but we kept pushing, and this was an industry-wide effort. And there are two cases that followed on that, which actually raises a much better and a more optimistic view of impossibility preemption. The first is PLEVA. In that case, it's generic medicine, and the generic medicine has a duty to follow the branded medicine in all aspects of its labeling. And so in a case involving a pretty commonly used drug called metoclopramide, or the brand name Reglan, the generic manufacturer convinced the court that it had a duty of sameness and therefore under federal law could not comply with the state law duty to warn theory posited by the plaintiff, and in fact the Supreme Court agreed. Then in the Bartlett case, following right after that, 2 years later, the complaint was, well, you should have designed the drug differently, or you should have pulled it off the market. Again, this was a generic drug, and again, the Supreme Court said, no, it's impossible to satisfy the state law requirement because you need to get, to change the design of the drug involves changing a molecule, which would require the federal agency to approve what in essence was a different molecule under federal law. Therefore, the Supreme Court said, we won't permit this. The company is within its rights, and we're going to give the federal law preemptive effect. So the industry is building upon these cases to really expand and to further define the scope of federal preemption. And I use this as an example because many industries, many businesses can actually take a look at federal law and take a hard look at it and start developing the record in order to make it clear to a court that either the claimant in a lawsuit or a state agency which is trying to impose its regulatory regime upon a company is in fact in conflict with an important federal law and should be preempted. So let's think about over-the-counter medications. I'm sure we all, maybe some of us had, took a Tylenol this morning or an Advil or a baby aspirin, but we all are taking over-the-counter medications, and the federal law heavily regulates over-the-counter medications. So it requires in certain respects that OTC medications be concise, that the drugs be approved as safe and effective, and oftentimes there are citizens' petitions and other actions challenging the label. So plaintiffs often will sue when there's an adverse event and say, well, gee, the label should have said X and it's not in there, or that the drug should be formulated differently. And the courts have gone both ways on this, but the point being, in trying to extend this doctrine further, you really need to paint the picture that in a functional analysis, that the industry is placed in an untenable position trying to comply with both state and federal law. And so you want to create a very dense regulatory record which demonstrates to the court that, yes, the federal record and the federal regulations are such that you shouldn't allow a state court plaintiff to impose additional or different requirements than what have been imposed by a federal agency. So this is Rick's preemption checklist, and this is really how, I look at any question that involves preemption. And if you were going to, remember anything from my talk, this is what I really would like for you to focus on. First, you ask the question, what do federal regulations require? The second question you ask is, what does the plaintiff allege you should have done, or what does the state agency impose upon your business, and how that differs from what federal law requires? And then you ask yourself the question, well, can you possibly satisfy either the plaintiff or the state agency without violating controlling federal law, federal principles? And lastly, would satisfying the plaintiff require a federal regulator to exercise their discretion and change the existing requirements? And that's the key. If you have to go hat in hand and ask permission, the likelihood is that the state law or the state law plaintiff will be facing a pretty stiff preemption challenge. And so this is really the key point, is taking a step back. If you're a heavily regulated industry and asking yourself, what am I being asked to do by this state actor, either an agency or a state court plaintiff? And take a sober look at it and see if you are placed in a conflict situation, and if the federal court would agree with you, or at least develop a record that Congress evinced an intent to give a law a preemptive scope. So again, here's the taxonomy. You've got the express and implied, the field, which is the seminal cases are in the immigration sphere, conflict, and then you go to things like mandatory airbags for obstacles, and then generic medications for impossibility. Other contexts, well, industries have been very creative, and mobile home, after Hurricane Katrina, and there was a lot of federal activity in making mobile homes available. And in that case, that there was a clean air standard that was in the regulation. There were some formaldehyde lawsuits were filed, and the federal courts said no, the state law claims were preempted because it would be an obstacle to the federal government, who actually specified the types of materials that could be used in some of these mobile homes. Forklift horns, you've heard the when they back up. Well, that's actually a heavily regulated sound. And when plaintiffs say, gee, I didn't hear that, or wasn't distinct enough, or whatever it is, in a product liability case, guess what? If you complied with the federal statute for backup horns, you're covered by preemption. It's a great defense. Environmental cleanup, heavily regulated. If you're in the business of an industry that has environmental exposures, please look at this. We've seen case law, and pretty recently, where the plaintiffs cannot comply both with the, it was an action brought by the federal government, and they actually prevailed in respect to the BP oil spill. So that's a line of cases. So again, where the federal government acts and the federal government is active, you need to take a step back and see, it's a burden, but where are the opportunities? So in closing, what I would say is this, that you need to just take the time and understand how the federal government impacts your business, what the regulations require, who's asking you to do something different, and then basically, with legal counsel, develop the strategy to see over time if you can develop the record to convince a judge of a federal preemptive effect of a regulation or law. This is only a framework. The key factor is convincing the court to give the federal law the preemptive effect. Where this defense is successful, the court has really agreed to do an in-depth analysis of the practicalities, the functional effect on your business, and has really will go on the record. It's a question that judges can decide. So at the end of the day, again, can you serve two masters is the question. And if you convince the court that you're being compelled to do that, they just might let your people go. So thank you very much. Have a good morning.